So once again, thank you for joining. This presentation is on our starting and stopping employment, starting and stopping relationships with your employees. And we'll have Sara Maenhaut speaking. And Leah, we can go to the next slide now, please. Just here's a little picture of our team, the WWH Financial Group here at Assante Wealth Management. You've got Jeff Wachman, myself, Per Homer, and Erik Wachman, and then keeping the lights on and making sure that everything is working the way it should. We've got Ose and Leah. So we can skip to the next slide, please. And then this is, no, next slide, please. So today talking will be Sara. Sara is an HR consultant. She has tons of experience with various HR issues. She's really great for the small to medium-sized business owner because what Sara can do is she can come in and help you with your questions as you go along, and you don't need to have an entire HR department to support you, but you'll still get the right advice. And so what we've really enjoyed is having Sara work with us. This is the second webinar we do with Sara, and hopefully one of many, where she talks to various business owners on this call and tells us a little bit about pitfalls and tips and tricks that we should be looking for. So that's about the limit of what people want to do in terms of listening to me talk. So Leah and Sara, why don't we flip to Sara's slides, and I'll let Sara speak. And again, there'll be plenty of time for questions. So please, we've turned it into a meeting session, so please don't hesitate to ask your questions. You can put them in the chat, or you raise a hand, and we will address your questions. Absolutely. So I'm sure there's be lots of great questions, and I'm really looking forward to them. And without further ado, Sara, rock and roll.
Thank you so much, Per. Thanks for the introduction, and to Assante for giving me the opportunity to speak to everybody today. A lot of familiar faces, a lot of familiar names in the group. Thank you for those coming. Excellent to meet those of you that I don't know. For those that have been to my sessions before, especially during Zoom, how hard it is for me to talk to little black squares. So if you're able, if you're comfortable, please turn on your camera. It's so much easier to talk to faces than it is to little black screens. So I appreciate that. Second, I apologize. We're having kitchen renos done. I wasn't expecting electricians to be this loud. So I've tried to suppress background noise, but if you hear anything, that's what's going on outside these four walls. So as Per mentioned, I am in the realm of human resources. I've been practicing for over 20 years, and for the last 5 years, I've been consulting through my own firm, North Star HR Solutions. I focus on providing HR support and services to small and mid-sized companies that don't need a full-time HR person, but definitely need help taking care of employee-related issues and taking that time off of your plate. I have clients in managed IT services, retail, HVAC, assisted living, and not-for-profit, just to name a few. And I'm here today to discuss a topic that strikes fear in the hearts of most business owners: ending an employment relationship. And along the way, we'll also start about kind of the happier side of things, and that's starting those relationships in the first place. So, full disclosure and my own disclaimer, I am not a lawyer, and although I make an effort to remain very knowledgeable on the topic, nothing I say today should be taken as legal advice. So before you implement anything we discuss today, I strongly recommend that you run it by your legal counsel. So today we're going to look at the employment relationship really in reverse. I'm going to start by talking about terminations. We'll review the concepts of for cause, or with cause and without cause. We'll look at the different components of termination pay, specifically under the Employment Standards Act or the ESA and under common law. Then, once I have you sufficiently scared of the costs related to letting your employees go, we'll go through ways to mitigate those costs. And all of that happens at the beginning of the employment relationship through a well-drafted employment agreement. As Per mentioned, I want this session to be as beneficial to you as possible. So please, although I ask that you keep your mics muted during the presentation, If you have questions related to what we're talking about at any time, unmute yourself, chime in, ask your questions, let's have a conversation. Or if you're more comfortable, put your questions in chat. And Per, if I can ask you to kind of monitor the chat line and come in with any questions as they come up.
I'm ready.
Okay.
We'll be here to moderate any questions, but yeah, everybody is pretty much muted right now, Sarah. So, but if anyone wants to pitch in and jump in and ask a question, please don't hesitate to hop in and unmute yourself and ask a question. All questions are valid.
Absolutely, and welcome for sure. Okay, so let's start by looking at the different bodies of law that deal with employment terminations. So the Employment Standards Act outlines the minimum guidelines that employers must adhere to. The Act sets guidelines on things like vacation, hours worked, overtime, pay, different leaves, and termination. On the other hand, there's common law. And this is not formal law. It's basically the precedent set by courts. When talking about termination, common law reflects how long a judge thinks it'll take a person to find another job. Termination pay under common law is meant to bridge that gap of employment. So a judge will look at factors like the age of a person, how long they were employed, the seniority of their role in the organization, their geographic location. So for example, a young semi-skilled person in an urban area will find it easier to get a job than an older, highly skilled person in a rural area. And in that situation, the older person is likely to receive more termination pay under common law because it'll likely take them longer to be employed again. So while the ESA remains fairly static, courts change the landscape of common law frequently. So it's always important to work with either a seasoned HR professional or your legal counsel before acting on a termination. Not only are there two types of laws to consider, but there's also two types of terminations. The first is for cause. We often think that terminating for cause means that we don't have to pay an employee any kind of termination pay. And certainly, although it's not actually called for cause or just cause under the Employment Standards Act, the Act does permit employers to terminate employment without pay or notice if the employee is guilty of willful misconduct. And you can read that whole definition on the slide here. Proving that an employee's actions are willful is very, very difficult, and that bar is set very, very high. However, there's also just cause under common law, and the bar is, I'll say, much lower. Under common law, you can terminate an employee without payment when the employee shows prolonged incompetence, period. That's all you need. Justice Brown described the distinction between the two very well. So let me read his words to you to help kind of clarify that difference. Willful misconduct involves an assessment of subjective intent, whereas just cause is a more objective standard. Willful misconduct is informally described as being bad on purpose. Careless, thoughtless, heedless, or inadvertent conduct, no matter how serious, does not meet the ESA willful misconduct standard. By contrast, common law just cause for dismissal may be found on the basis of prolonged incompetence without any intentional misconduct. So hopefully that clarifies the difference. So simply, you may have just cause to terminate an employee for poor performance under common law, and therefore you don't have to pay anything. But it's very difficult to prove willfulness, that someone was bad on purpose, and therefore you may still have to pay the ESA termination pay. This is a very confusing concept, and I bring it up only to bring awareness to you. But again, when you, or if you are ever in this situation, talk to an HR professional or your legal counsel before trying to claim a for cause termination. The second type of termination is without cause. As long as it's not discriminatory under human rights or against a protected leave under the Employment Standards Act, you can terminate anyone for any reason as long as you pay them enough. Under the employment standards, this simply means anything that isn't willful misconduct would be without cause. Poor performance, poor attendance, poor attitude, insubordination, these all fall under without cause and therefore do require some type of termination pay. So again, although it's important for you to understand the distinctions and the differences, because it's so difficult to prove for cause, I'm going to focus the rest of the webinar on the without cause terminations. This is really probably 99% of the terminations that you're going to face. So let's focus on that. So here's the meat of it. Let's jump in. First, we're going to look at the costs associated with employment standards, and then we'll look at the cost associated under common law. So under employment standards, there are potentially two parts of termination pay. There's termination pay and severance pay. And let's look at both in a little bit more detail. So the first part is called notice. You, as an employer, have the obligation to provide notice to the employee that you're ending their employment. And this can be done in one of two ways. First, you can provide working notice, which means that an employee continues to work for you until the end date or their termination date. And there's some pros and cons to this. Certainly on the positive, when you provide working notice, you keep all of the employee's knowledge during that transition period. You get the benefit of continued productivity in return for the cost of paying the employee. And if the employee happens to resign during the notice period, it could save you money in having to pay out the common law payout. And again, we'll talk about that common law in a minute. On the flip side, though, there's definitely some cons to working notice. The affected employee may create a poison work environment for the others that are still working with you. The employee may not be as productive during the working notice. Certainly they've been told that their employment is ending. There's not the motivation there to perform as there was even the day before. There's the risk of the employee injuring themselves on the job and going off on WSIB, short-term disability, or even long-term disability. There may be an increase of workplace violence or sabotage against the company. There could even be an increased risk of the employee stealing or leaking confidential information to your competitors. So those are the things to weigh when you're thinking about giving working notice. The other way to provide notice is to give payment in lieu of notice. This means that employment ends today, but you're going to continue paying the employee their regular pay plus vacation pay and benefits for the duration of that notice period. And of course, there's pros and cons to payment in lieu of notice as well. On the positive, the affected employee is out of the company immediately, so there's no longer the risk of a poison work environment, confidentiality leaks, sabotage to the company. And also, you can choose to pay the in lieu amount as a lump sum or as a salary continuance, as long as the employee agrees to receive it as a salary continuance. And that means you get to choose the cash flow that works best for you and your business. On the other side, when the employee walks out, you lose their knowledge as soon as they walk out the door. So there really is no transition period. You're paying wages without the benefit of getting the productivity in return. So that is notice. The other ESA requirement is, sorry, looking at my chart here. Let's go back to notice period first. Here is the actual notice period that the ESA outlines. This chart shows again the minimum notice periods that you're required to provide when terminating an employee. So you'll see that there's no requirement to pay anything if the employee's been with you for less than 3 months. This is traditionally and informally called the probation period. Notice is typically 1 week per year of service, up to a maximum of 8 weeks. So even if an employee has been with you for 20 years, you're only required to pay them 8 weeks of notice. And we'll talk about what else you'll owe them shortly. So remember I said there's 2 parts under the termination pay. The first was notice. The second is severance. Severance does not apply to everybody, so we'll keep it simple here. First, severance only applies to employers who have a total payroll of 2.5 million or more per year. If your payroll isn't this large, you don't have to pay severance when terminating employees. You only have to pay the notice portion. If you are over the total payroll threshold, the next test is the length of service an employee has been employed with you. Service is considered an earned benefit for long service employees. Sorry, severance is considered a benefit for long service employees. So employees only become eligible for severance once they've been employed by you for 5 or more years. But an employee who's been with you for 3 years is not entitled to severance. So let's assume that you meet both criteria for severance. Here's how you'd calculate the amount. Severance pay equals 1 week of regular pay for each year of service, including months, so parts of year, up to a maximum of 26 weeks. So again, for example, an employee who's been with you for 6.5 years is entitled to 6.5 weeks of severance pay. Severance is paid in addition to notice. So continuing that example, an employee who worked with you for 6.5 years would be entitled to either 6 weeks of working notice or 6 weeks in pay in lieu of notice, plus 6.5 weeks of severance pay for a total of 12.5 weeks. And remember, these are just the minimums. These are what you must pay according to the employment standards. The actual amount depends on many more factors like common law, and we'll talk about that next. Before I go through a quick example, does anybody have any questions regarding notice or severance?
Sarah. Yeah, we've got a bunch of questions here.
Excellent.
So the first one relates to ESA versus common law. So ESA is the legislation. Common law is law that's created through court cases, as we know. And so can you just talk a little bit about how those two work together?
Yeah, absolutely. So again, the employment standards you must pay, non-negotiable. You cannot contract yourself out of employment standards. It is the minimum that you have to pay. The common law amount is again what the courts are saying employers should be paying. There are ways around it, and we'll talk about that soon. And I'll talk about what common law is and what it looks like in our next couple of slides. But without anything else in existence, an employer is required to pay common law plus employment standards. Okay, and employment standards is common law is inclusive of the employment standards amount. Okay, and I'm not going to go into too much detail because we'll talk about common law in a minute, but I hope that answers just the distinction and how they work together.
Yeah, Zan, I see you've got your hand up and you're unmuted. So if you want to do a follow-up question there, please go ahead.
So with regards to amounts, it's understandable. One is layered over top the other. But when it comes to the set of rules, that's where I'm confused in terms of ESA. If ESA are minimum standards, and we're talking about notice, for example, or severance, it's a little difficult to understand now. There's no layering there that we're talking about because the ESA, for example, the with or without cause thing, the ESA is more, you said it's, anyways, I'm having a hard time reconciling the two sets.
So let's not think about the without cause right now, because again, from an employment standards point of view, that bar is so high, you will probably never meet it, to be quite blunt. But when we're talking about amounts, you always have to pay that notice period. And the notice period, and I'll just go back a couple slides if I can. Oh, there we go. This is, again, the minimum amount that you must pay under notice. And this is the basically 1 week per year of service. That has to be paid. Then the severance is if you meet those certain conditions. If your payroll is above 2.5 million and the employee has more than 5 years experience, then you must pay severance. Severance, again, is 1 week per year of service, up to 26 weeks. So those work together. So in our example, for 6.5 years of employment with you requires 6 weeks of notice period plus 6.5 weeks of severance for a total of 12 weeks. So that's the great thing about employment standards is it's very clear cut. They tell you exactly how to calculate what is owed to the employee. Then we layer on common law, and that'll become a little bit more clear as we continue talking. But that's kind of the great thing about employment standards is it's clear exactly what is required under both types of termination.
Thanks, Anne. That's a great question. And 2 other quick questions, Sarah, before we go ahead. They both relate to ESA. For construction, is ESA different for the construction business?
Oh, yes. Yes,
Sorry.
it is. So there are, under employment standards, there are some industries that are exempt from different types of factors under the employment standards. And construction and termination are one of those special rule industries. So under, and you're testing my knowledge off the top of my head, under employment standards, you are not required to pay, I believe it's notice. And if whoever is asking this question, if you and I want to connect afterwards, we can look this up and be specific for you. But yes, in general, you do not have to pay the notice period under employment standards for the construction industry. And there's a very specific definition of what construction is and is not. So again, for whoever's asking that question, we can get into whether or not you fall under that.
So in summary, be super careful if you're in construction.
Absolutely.
And then the other one, does the ESA and the common law apply to federally regulated businesses in Ontario?
Oh, great question. Great question. So this is only for provincially regulated employers.
Mm-hmm.
We're not talking about federally regulated. They would be covered under the Canada Labor Code. So today we're just focusing on Ontario provincially regulated companies.
Okay, great.
And I should put another caveat in there. We're talking about non-unionized environments. Right. Companies with a union would be, they'd be dictated by their collective agreement.
So people that are in either the federally regulated businesses or in unionized workplaces should contact you afterwards to go over their particular complexities.
Exactly. Yeah, for sure.
Thank you so much, Sarah.
Okay, no problem.
Great questions, guys.
Okay, so hopefully this will help, this example will help you think about what we've talked about so far and some of the questions too. So let's look at this quick example. Steve has been a customer service rep for 15 3/4 years, so 15 years, 9 months. He earns $26 an hour and he works for 40 hours a week. He has poor attendance and his employer has decided to end his employment without cause. The company's total payroll is $500,000 annually. So first question, can anybody tell me what kind or kinds of termination pay is Steve entitled to? And I'm going to warn you, if I don't hear from anybody, I'm going to pick on the faces that I see. Based on the information we have here, what kinds of termination pay under employment standards would he be entitled to? Oh, Gary, do you want to try?
Notice.
Absolutely. And why do you say that?
Well, it's only notice because the payroll is not 2.5 million and above. Therefore, the second one doesn't apply.
Perfect. You're absolutely right. Everyone's entitled to notice, so he will get notice, but because the company's payroll is less than the 2.5 million, Steve's not entitled to it, even though he's been with the company for 15 years. Fantastic. Great work, Gary. Okay, second question. Assuming that Steve will be paid out his notice, so he'll be given pay in lieu of notice, what will the total termination payout be? Does anybody either want to do the quick math or at least walk me through the calculation? Nancy, I'm loving watching your balloon bounce in the background, so I'm going to pick on you here.
8 weeks. You got 8 weeks.
Yeah, it'll be 8 weeks of notice, absolutely. So how do we determine that total amount?
$8,320.
Say that again?
8,320.
Fantastic. That's exactly right. Can you walk us through your calculation, your formula?
Okay, so it's 26 hours, $26 per hour times 40 hours per week. So it comes to $1,040 times maximum of 8 weeks notice period. So it comes to 8,320.
You are exactly right. Bang on. Okay, so you want to find out their weekly amount that they're being paid, multiply that by the notice period, and in this case, it's the 8 weeks. It's the maximum amount that he gets under notice. So the total termination pay is $8,320. Okay. So it's important. Sorry, is there a question there? Comment? Okay. It's important to note here that these costs, as I mentioned earlier, they're legislated. They are non-negotiable. These are the minimums that you must pay when you terminate an employee. You cannot contract out the employment standards. You cannot agree with the employee to not pay employment standards. You must pay at least this much. Okay? So on top of employment standards, there's also these common law requirements. And remember, common law is basically the precedent set by courts. It's how long a judge thinks it will take a specific person to find another job. Common law payments of termination are typically 4 weeks of pay plus benefits per year of service, up to a maximum of 104 weeks or 2 years. Common law payouts include ESA minimum requirements, meaning you don't have to pay ESA plus common law. Common law is inclusive of the ESA requirements. So compare that. That's a huge, huge difference. Let's look at the same situation again from a common law lens now. So we have Steve, our customer service rep, 15 3/4 years of service, earning $26 an hour, working 40 hours a week. Steve is 58 years old and he lives in Wyerton. He has poor attendance and he's being let go without cause. Company's total payroll is $500,000 annually. Okay, so again, what does the company owe Steve in termination pay? Let's just look at the common law. How much do they owe him in common law?
$1 bajillion.
Pretty close.
Yeah.
Pretty close.
Mm-hmm.
Let's look at that. So it's the same calculation. It's 4 weeks per year of service times the 15.75 years that he's actually been employed with you. So 63 weeks you owe him. 63 times the 1040 is what he currently earns per week. What's my number here? $65,000, 520. Compared to only the $8,300 under employment standards.
I was close.
Yeah, you were close.
Yeah.
And on top of this, you're also continuing his benefits for 63 weeks. Okay. Now, remember, this includes that $8,300 that you're required to pay, but it's still so much more. There is a huge difference between common law and employment standards. So as our example shows, terminating employees under common law is an expensive endeavor, but fear not. There are ways to reduce the amount that you're required to pay upon termination. It just takes a little bit of pre-planning and a good HR consultant or lawyer. Let's look how to do that. Before I move on to employment agreements, are there any questions about terminations? Zan, I see your hand up.
This might be answered, and so you can tell me if it's going to be answered in the future. But again, it's this about ESA is the minimum requirement. Common law is up to what it could go to. I'm assuming that there is technically not flexibility per se, but there is the ability to negotiate that amount somehow, either through an agreement or through some negotiation of some sort. So
exactly. Yeah. And that's a perfect lead in to our talk about employment agreements. Yeah. In the absence of no agreement, you are required to pay the full amount.
Oh, okay.
Okay. A judge will look at that and say, you didn't agree to anything beforehand. You can't now come in and try to negotiate a lower amount. Therefore, you're required to pay the entire common law amount. But again, that's why it's so important to implement these employment agreements up front. Okay, any other questions? Okay, let's keep going then. So first, and probably most importantly, an employment agreement clearly outlines the terms and conditions related to being employed by your company. We'll talk about what the terms and conditions should be and what we should outline in the next slide, but really that's the meat of an employment agreement, is to outline those expectations. It sets clear expectations and it removes any kind of ambiguity for all parties. Everyone, both sides know exactly and agree upon what they can expect and what is expected from them. And finally, an employment agreement increases your professional image. It shows you're not a Mickey Mouse organization just flying by the seat of your pants. Rather, you're familiar with employment law and your employees' rights within it. And this isn't just a feel-good benefit. This is practical. When employees feel comfortable that you know the law, they're going to be less likely to question you and your knowledge of it in the future and question your future actions. So you're really setting that image up front. There are many clauses that should be included in an employment agreement, both to set those expectations, but also to protect yourself and your business in the future. So let's review, I'll say some of the clauses. You can certainly put more in, but here's what I recommend is the bare minimum. So your employment agreement should include conditions of employment. So this section outlines any items that could affect the employability of the new hire. Things like reference checks, a clean driver's abstract, criminal background check, a vulnerable sector check, anything that the employee must prove success in before employment begins. Otherwise, the agreement is null and void. Okay, so the offer is conditional on a clean driver's abstract. Should you fail to produce that, this entire offer is null and void. We don't want to hire you. You want to clearly state what those conditions are. The next piece is all the particulars in terms of title, reporting manager, location, hours of work. These should all be very clearly laid out in the agreement. I encourage you to include a brief description of the role or reference to a job description. It makes it clear, the clause should also make clear that you maintain the right to make changes to their duties as the business sees fit. You want to include a start date. Seems simple, but you want to be clear on what the first date of employment will be, because this date will be used for seniority purpose going forward. So you want to ensure that it's correct. Make sure that you include a clause around probation period. Outline how long your probation period is. Most are 3 months, but some are 6 to 9 months. outline the purpose of probation, and reserve your right to extend probation if needed. Obviously, you want to include a clause around compensation, include the starting regular, either hourly rate or annual salary, plus include any details and payout conditions around bonus or commissions that the employee will be eligible for. You want to talk about overtime. Describe whether the employee is eligible for overtime, because not all employees are. Outline how overtime is handled within your organization. Talk about vacation. Again, briefly outline your vacation policy, clearly stating how much vacation time and or pay the employee is entitled to going forward. Include a confidentiality clause. Oh, giving everything away here. Confidentiality clause, you want to prohibit your employees from sharing company secrets both during and after their employment with you. I would recommend including a non-solicitation clause. So as of late 2021, Ontario employers are no longer allowed to impose a non-compete on their employees. And the details of this ban, maybe they're a topic for another day. They're certainly much bigger than what we have time to talk about right now. But for now, know that a non-compete is not allowed within Ontario anymore. But you can still have your employees sign a non-solicit, stating that they'll not try to induce your customers or your staff away from your business, either during or after employment. Make reference to your policy manual. Talk about either your manual or your employee handbook and outline the requirement of the employee to abide by all company policies while they're employed by you. Mention layoffs. Mention even the possibility of a future layoff, no matter how slim that chance may be. Putting an employee on even a temporary layoff without having a clause to do so could lead to an expensive constructive dismissal claim. So avoid that by setting a simple expectation at the beginning of the relationship. And finally, your agreement should have an encouragement to seek legal advice. So a clause that says either get legal advice or confirm that you've been given the opportunity but have chosen not to. So those are, I'll say, the 13 that must be included. But what's the most important clause that I'm missing in this list so far? The termination clause, right? The reason that we're all here. This is probably the most important clause to include because it protects you and it protects your business more than any other clause in an employment agreement. I agree, nobody wants to be thinking about termination when they hire a new employee. This is supposed to be a happy time, the coming together of two people for a long and hopefully successful relationship. But by being proactive at the beginning and including a clear and compliant termination clause, you can save yourself from having to pay those massive common law termination payouts and only have to pay the minimum ESA requirements. Now, to Zan's point, there is a large difference between the minimum ESA and the maximum common law. For small businesses, a lot of them that I deal with want to limit their exposure to just the employment standards. So you can word a termination clause that limits you to just paying employment standards. But if you feel that you want to and perhaps can afford to offer more, you can do that. You can, for example, instead of offering 1 week per year of service, you can offer 3 weeks per year of service. So you're not quite at the max employment standards, max common law, but you're close. Okay, you can certainly do that. Just make sure that under all circumstances, you're at least agreeing to pay the minimum employment standards. So if you think that your payroll might grow beyond 2.5 million and you'll be required to pay severance someday, your clause now has to take that into effect. You always have to be paying and agreeing to pay at least employment standards. So you can absolutely offer more. Termination clauses are always being challenged in court, and the legal landscape on them is constantly changing. Only a year and a half ago, there was a massive ruling in the Ontario courts changing the way termination clauses are worded. So because of that, I'm not going to go into a lot of detail here on how to write a termination clause. Instead, again, I'm going to strongly encourage you to get professional help. Talk to someone, either professional HR or your lawyer, who knows what those clauses currently are today in order to be compliant, because they do change often. And your agreements have to be so very carefully worded. As this most recent case proved to us in the industry, even a sentence or a few words that are found to be non-compliant can nullify your entire termination clause. So you really want to make sure that the entire clause is tight. And finally, just to reinforce what Zan had asked, just because you offer the employment standard minimum doesn't mean that you can't pay more if and when the time comes. So for example, if your employment contract states that you're only going to pay the employment standards minimum upon termination, but you have an office manager whose job has become redundant because of new technology. She has been a wonderful performer. She's been with you for 10 years. She's a real key member of the team. You can't afford to keep her anymore. You can absolutely offer her more than what her contract has stated. Okay, you just can't offer her less. So even when the time comes, if you have an agreement, you can offer more than your agreement says. Okay.
Okay,
so sorry, go ahead, Per.
I'm going to butt in. A couple of questions. So first of all, this employment agreement, that sounds like a really important idea. Where do we get one? How do we get an employment agreement?
So I definitely recommend, if you don't have one, talk to your legal counsel or talk to an HR professional. And you're welcome to call me, but I don't mean this to be a sales plug. You can get them online, but I caution you when you do that. Again, because the laws are changing so frequently, you're not sure where the agreement online is coming from. Is it relevant to your province? Is it relevant to your industry? Is it still compliant with current laws? So I would say definitely either your lawyer or your HR professional. That's where you should be getting agreements going forward.
Okay, and I'm going to throw the mic to Zan. He's got a question here, and I'll oh, here, sorry. I think we're just unmute yourself there, Zan, and throw out your question. I think I muted you again by accident. I apologize.
So I don't mean to hog the platform here, but a question on start dates. So we had a situation where, so I write an agreement and it says effective such and such date. And then what ends up happening is the first shift might actually be a little further down the road because certain things didn't happen. Now, our bookkeeper in QuickBooks, because a lot of this is related to money at the end of the day, gets her start date in the system is more about her first day worked, and ROEs, records of employment, calculation of years of service, and at what point in time does their vacation pay change, all seems to center around that first work date. Now, I need to know what the difference is between the date on the agreement versus the date, first day worked, actual day worked.
I would recommend that they be the same, that the start date on the agreement should be the actual first day worked. And that may change. You're right. You might decide in February that March 15th is going to be the first day of work. And for whatever reason that changes and it gets pushed back to March 20th. In those situations, I recommend, and you can even write it in, just cross out the date on the employment letter, employment agreement, put the new date, initial it, have the new employee initial it, okay, and then you're good to go.
So we update that. Okay.
Yeah, but definitely keep that updated. But your bookkeeper's right. In terms of seniority, it should be the first day worked. But let's make sure that all of our documents support that as well.
Okay, great.
Anything else, Per?
Not yet, no.
Okay. we're almost done, so it's almost time to open it up for those questions. I really like this quote from Patrick Dixon. It says that business strategy and planning is the battle plan for a better future. So again, a little planning at the beginning, being proactive and creating that employment agreement to solidify the employment relationship goes a long way and leads to a much more risk adverse and profitable future for you as a business.
Great.
So I want to thank everyone for sharing their questions. That was great. Before I open it up to everyone's open questions, there was a few questions that came through the registrations that I want to address.
Right. So before we get to that, we're just going to
Okay.
throw up a couple of slides, and then we're going to go to our questions slide. We'll go to the questions that people had in the registrations, and then open forum for people to ask them questions. So Leah, can you just throw up the next slide, please? So just before we get to the questions, we're just going to go through our next events. So towards the end of this month, beginning of this month, people start thinking about their taxes. We do have 2 Ask Me Anything webinars on personal and corporate taxes coming up. So if you're on this webinar, you will get an invite to join that if you'd like. If you don't see that, just do reach out. And then we'll have further webinars in April and May that we're going to touch base on. So next slide, please, Leah.
So that's your commercial break, Para.
That's my commercial break. That's right. And here's Sarah. Here's her phone number. Here's her email address. All right, Sarah, you had a couple of questions that people put in through the registration. Thank you for doing that. That always improves the quality of our presentations and allows us to address them and think a little bit ahead. So Sarah, why don't you knock those off and then see if anybody else has some more questions, please.
Okay. Thanks for sticking around during the commercial break. I love that reference. Okay, so somebody asked, when buying a company, should you create new contracts with existing staff? What are some of the pitfalls and risks? So I'll be honest, this is a huge question and a topic kind of in and of itself. And maybe it too is another topic for a future webinar. But the short answer is yes, you should absolutely prepare new employment agreements for all remaining employees when you purchase a business. For one thing, it provides a contract to employees who may not have had one under the previous owner. It acts to set clear expectations under the new owner. And it creates protection for you, as we've discussed today, by including clauses that protect you and your business. And finally, it clarifies the continuity of seniority for employees because their seniority does continue. If you purchase an organization today and you keep the employees that were in it yesterday, they continue their seniority. So 1 week from now, if you decide that someone's not working out in your new company, but they've been with the previous company for 20 years, you still owe them 20 years worth of termination pay, as we've discussed today. So again, very important to clarify that and to set those ground rules and potential limitations within the clauses of a new agreement.
And that's something that we often recommend when we see clients buying businesses, is to have a open and transparent conversation with the seller about the existing employees and what would happen if during a certain period of time, maybe 3 months or 6 months, if you need to let somebody go, and who's going to bear that severance cost. Because I've seen situations where someone needs to unfortunately got to let somebody go because they're not happy with the new ownership or what have you, and it's been 2 months, but they've been there for 20 years. There's a large, as we saw today, there's a large financial liability there. So it's good to see if you can negotiate something into your contract when you buy the business to see if the seller will bear some of that, or otherwise ask them to repaper some of the contracts. And if you do have contracts with all your employees, it also is really good when you're looking to sell your business. It makes it more attractive to the buyer as well.
That's a great point, especially if you've got a strong agreement in place, showing that you have limited some of the potential costs and burdens to the organization. Definitely makes it more attractive. Okay, another question that we received is, what happens to my CPP contributions when I change employers? So a little bit outside of the scope of what we're talking about, but still a great question. Your contributions to the Canada Pension Plan remain with the government until you begin to collect it, regardless of what employer you're with. So as you move to different employers throughout your career, they will continue to submit your CPP contributions on your behalf. And if you happen to change employers after you've already reached the annual maximum contribution for a year, the new employer is obligated to continue to contribute or withhold those contributions, submit on your behalf. However, I do believe that you would get that overpayment back on your income taxes. So again, a little bit outside of the scope of today, but I'm thrilled that people are asking questions. So I hope that answered it. We covered a lot of information here, and I know that we did it quickly. So let me open it up now. Are there any questions about termination, employment standards, employment agreements that anybody has?
Got another question for you here, Sarah. Do you provide advice to employers or employees or both? How do you go about it?
So I can do both. I do both. Mostly I provide advice to employers, but I do have a couple of clients that have opened me up to their organization, and I am their HR person that their employees come to. And then it's a balance. You know, it's just like an internal HR person. It's how do we keep your employees engaged and motivated and heard, and at the same time keep your company protected.
Great.
So I do both.
Sarah,
Yes.
this is Jim Brand. I own a small private Montessori school. Contracts with those small schools or childcare tend to be a yearly contract. I was wondering, and we're non-unionized, I was wondering if there's anything that you've said so far that you would say, okay, doesn't really apply in the same way as you've said there are exceptions for the construction industry. Is there anything that we should be aware of that's different from what you've laid out to this point?
So I would say at the foundation, everything that we've talked about does still apply to you and to the school. It's a great question. I've actually got a private school client, and I believe she's with us today. And we've had a lot of discussions about that ongoing contract. And it's a difficult one. So just for a little bit of background, under the eyes of the law, when someone starts to look like an employee, even if you call them a contract, a fixed term contract, the more you treat them like an employee, the more they start to look like an employee under the law. So even though I'm only employing you for this year, if I employ you for this year and then this year and then this year and then this year, now you've been with me for 4 years, it's kind of expected that that agreement's going to get extended. They start to look like an employee, and you are now required to pay them when and if terminated as if they were a continuous employee. They've been with you for 4 years, 5 years, whatever that is. So as long as you're aware of that, you can continue to have the contracts. But I would recommend either convert them to full-time, or just be aware from an organization point of view that you are going to have that burden when you terminate. And as long as you're financially prepared for that, then you're fine.
Thank you.
Okay.
Another one here. We've got a few more in here. Another one. So if a company changes its identity, or as in it's dissolved, and then it incorporates under a different name with different owners and carries the same employees, do the original employment agreements still hold, or more to the point, is that person's employment, if they were ABC incorporated with me as an owner, and then the next day it's XYZ incorporated with you as the owner, but the employees continue and they're doing substantially the same thing, does the liability still continue?
It does, yeah. Again, I've had a client go through the same thing, a complete brand change, name change, ownership change, but same employees working in the same job, same location, same equipment, same clients. So it is the same employment relationship. I do recommend, though, you still put in a new employment agreement under the new company name, but know that their seniority is flowing with them into the new company.
Yeah, that makes a lot of sense. And then I think there's a concept called inducement that can be that the employee can apply there as well, right? So that's one of the reasons why it flows through.
Yeah.
Now, who is not eligible for overtime pay? How do we know who's eligible and ineligible for overtime pay?
So at a high level, managers and supervisors, so anybody that manages people, is not entitled to overtime. And then we get into the specific rules for different industries. So for example, I know under construction, they are not eligible for overtime. Very large question. IT professionals are not entitled to overtime. I'd have to look into the other rules to know what the other exemptions are, but there are some industries as an industry that are exempt from overtime. But for everybody, managers and IT professionals are not entitled.
I think we have time for one more question. That kind of is the limit of questions that I had on the chat. But if anyone wants to unmute, we've got another minute or two, and then we'll give you back your time. We have taken an hour of everybody's time. I think it's been really great, Sarah. Thank you so much.
Absolutely. Anyone want to take that last time?
All right, Final Jeopardy. Got a lot of thank yous coming through, but thank you so much, Sarah, for joining us yet again. Thank you, everybody, for joining us. It was a fantastic turnout with well over 30 people joining the call, and that's really heartening to see. I can't tell you how much we appreciate your expertise, Sarah, and the time that you've spent with us. So thank you, everybody.
Absolutely. Before everybody logs off, if there are any other questions, I am happy to give everybody on this call just a 15-minute conversation to answer any questions that you have, and a quick conversation free of charge, no problem. Give me a call. I believe it's oh yeah, you've got it on the slide here. Feel free to reach out. I'm happy to continue the conversation.
Absolutely, and we will be sending out thank you emails to everybody, and there will be a recording of this shared and posted to our YouTube channel once compliance agrees. So thank you, everybody.
Yep.
Right, enjoy the rest of your day, everyone. Thank you.
All right, enjoy the warm weather.
Thank you.
Thank you.
Very welcome. Good to see you, Zan.
Thanks, Anne, for your participation.
Thank you.